Welcome to K&L Gates' Working Wise podcast series. My name is Spencer Hamer, and I'm a partner in the Orange County office of the firm's Labor, Employment, and Workplace Safety practice area. In this podcast, I will discuss recent trends in pay equity law, as well as proactive strategies employers can implement to promote pay equity in the workplace. In recent years, pay equity issues have been front and center in the news, on social media, and in legislatures throughout the country. And with increasing awareness of pay equity issues comes increasing litigation. Lawsuits over pay equity, and more specifically class action lawsuits, are on the rise as new laws are passed, employees learn more about their rights, and lawyers become more interested in taking on pay equity cases. In recent years, several corporate giants have been hit with pay equity lawsuits. These cases are typically brought under the Federal Equal Pay Act, which requires equal pay for equal work, as well as counterpart state laws. In fact, more than 40 states, including California, New York, New Jersey, and Massachusetts, have enacted their own equal pay laws. Let's look at the legal background. Under the Federal Equal Pay Act, employers cannot pay lower wages to employees of the opposite sex for equal work, the performance of which requires equal skill, effort, and responsibility, and which are performed under similar working conditions, except where such payment is made pursuant to a seniority system, a merit system, a system which measures earnings by quantity or quality of production, or a differential based on any factor other than sex. The jobs to be compared need not be identical, but they must be, quote, substantially equal. Job content, not job titles, determines whether jobs are substantially equal. Skill is measured by factors such as experience, ability, education, and training required to perform the job. The issue is what skills are required for the job, not what skills the individual employees may have. Effort measures the amount of physical or mental exertion needed to perform the job, while responsibility measures the degree of accountability required in performing the job. The Equal Pay Act is a strict liability statute, meaning that unlike plaintiffs suing under anti-discrimination laws, an Equal Pay Act plaintiff does not have to prove discriminatory intent. Rather, they only need to prove that he or she received lower pay than the average wages paid to all opposite-sex employees performing substantially equal work. Pay discrimination on the basis of other protected characteristics such as race, ethnicity, and national origin is also prohibited under federal law by the Title VII of the Civil Rights Act, as well as by numerous state anti-discrimination laws and, increasingly, state equal pay laws. Moreover, many of the state equal pay laws contain standards that differ from the federal law, which creates additional compliance challenges for employers. Furthermore, making matters more complicated, numerous states have enacted laws prohibiting employers from asking about salary history at the application stage. The theory behind these laws is that pay discrimination at past jobs should not be permitted to follow employees throughout their careers, transferring discriminatory practices from one employer to another. In addition, several federal courts that have considered the issue have held that employers cannot justify wage differentials between men and women by relying on employee compensation at prior jobs. A recent federal case against Uber illustrates the class action pay equity lawsuit trend. In Del Toro Lopez versus Uber Technologies, Inc., 3 female engineers filed a class action in federal district court in Northern California on behalf of approximately 400 other female and racial minority software engineers at Uber. They alleged that Uber had violated the Equal Pay Act by paying the class members less than their white and Asian male colleagues for doing the same work. Specifically, they claimed that Uber used a discriminatory system of, quote, stack ranking, and that under this system, supervisors ranked employees from worst to best as a method of evaluating work performance. But the system, according to the plaintiffs, undervalued female minorities who received, on average, lower rankings despite equal or better performance. The rankings were then used, in part, to determine promotions, which resulted in lower pay for females and minorities. In addition, the plaintiffs alleged that Uber based employee pay on past compensation, which further disadvantaged women of color who were paid less on average than their white and Asian coworkers. During the case, 56 former and current employees came forward to describe their experiences with discrimination and harassment at Uber. The lawsuit was filed shortly after an Uber employee made a blog post in February 2017 describing Uber's work environment as one that tolerated and fostered sexual harassment. The parties reached a settlement in November 2018, and under the terms of the settlement, Uber without admitting wrongdoing, agreed to pay $10 million to the class, including $2.6 million in attorney's fees. It also promised to implement a new pay structure, develop a validated promotion assessment process, regularly report demographic data on its workforce to the court, and make changes in its management ranks. Furthermore, Uber agreed to provide diversity and inclusion training, create a mentorship program for class members, and publish a diversity representation report at least twice a year. Additionally, it agreed to hire an independent consultant to conduct a pay equity bias review. Uber also promised to revamp its performance evaluation process by specifically monitoring statistics regarding the class members. This case, along with many others recently filed against employers across the country, highlights the importance of proactively focusing on pay equity issues before an unhappy employee posts negatively about the company online or a lawsuit arises. The good news is that employers can take proactive steps before negative publicity or litigation comes about. The best place to start is by conducting a pay equity audit. To do so, we recommend the following. First, make sure that the audit is conducted under the guidance of legal counsel so that it can, at least during the initial stages, be considered attorney-client privileged. While you may eventually want to remove confidentiality from the results and share them with third parties, including employees, the initial stages of the audit, at least, should fall under the privilege. Among other things, this will facilitate information sharing as well as frank and open discussion and analysis of potential issues. Second, using a spreadsheet, identify the group or groups to be analyzed, the data to be collected, and the individuals who will be conducting the audit. A pay equity consultant may be necessary for matters that present statistical complexity, such as a regression analysis. Third, look for differences that cannot be attributed to lawful factors other than sex, race, or other protected characteristics. Determine the reasons for the discrepancies, make changes where necessary, and evaluate the method by which changes will be communicated to any affected employees. Fourth, determine a protocol for going forward. Steps to consider include updating policies, procedures, and handbooks, training managers on pay equity and anti-discrimination, ensuring that the hiring process is set up so that salary band laws are complied with, and salaries are set based on predetermined, objective, and consistent factors tied to the position at issue. Consider implementing pay ranges or bands to prevent significant disparities, and use the pay equity audit as a basis for ongoing audits conducted at least annually while updating the spreadsheet at least quarterly. When dealing with your employees, be transparent about compensation factors both during the hiring process and annual evaluations. Solicit feedback on compensation from employees both directly and through surveys or other methods. Maintain current job descriptions and ensure that merit-based pay increases for current employees are directly related to objective evaluations of the job duties at issue. Ensure performance evaluation standards are neutral and based on objective factors. Consider methods by which qualified candidates can be sought out as potential candidates, regardless of gender, race, or other protected status. And finally, consider expanding the audit to race, ethnicity, and other protected categories. Taking steps to confront pay equity has many benefits beyond legal compliance, such as improving morale and reducing turnover, making your company more attractive to job candidates, and setting an example for your industry. And if you do happen to receive a pay equity complaint or claim after you have conducted an audit, you will likely have a much stronger legal defense given the hard work you have put in advance to confront the issue proactively. We hope you enjoyed this episode of K&L Gates' Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.